your counsel for discipline as of September 2nd of last year, which isn't of any great significance, except that now that I'm a government employee, I understand that that gave me 0.89 of a vacation or sick day on my leave notice that I just looked at again this morning because we're about to go into a new month. Anyway, before heading over to counsel for discipline, I was in private practice in Omaha for almost 30 years. My wife and I graduated from Creighton University in 1984, and we graduated from Creighton University School of Law in 1987. My wife is an attorney with the Social Security Administration in Omaha, which is one of the reasons why I get to commute an hour every day to and from Omaha, because there won't be any moving for us. In addition to private practice, I volunteered on the advisory committee to the Nebraska Supreme Court, and I was chair of that committee for approximately 5 of the 10 years I served on it. I do know that my service on the advisory committee went a long way to getting me in a position to get this job. So my service on the committee, it paid back more than I put into it. It's like about anything else you do when you volunteer. But the reason I bring that up is I would really strongly encourage you to feel comfortable calling me in my office to ask any question you might have about any area of law, and I know some of you have done that, and we're there for you. I'm going to start talking about ethical standards and criminal representation. There's been a push nationally. I attended my first National Organization of Bar Counsel conference in Houston. There's been a push with a lot of what you see in the media about what are we doing to enforce our prosecutors. I understand I was criminal defense attorney for a number of years and found that very rewarding and took that job very seriously. So I'm not here to talk about picking on my fellow government employees who happen to be lawyers who happen to prosecute. We just want to make sure that the rules are followed and they're followed fairly. But just as an overview, I want to talk a little bit about my office, what's new, and what isn't going to change from the 30 years plus that Dennis Carlson was there. A few things about the American Bar Association audit, that if you're a cynic, you think they purposely did. Well, Dennis had 1 foot out the door, and I had 1 foot in the door, so there was really no input from a director or future director. And some of the changes that they've recommended that we intend to implement or already have implemented at my office. With that, we'll get going here. I wouldn't discourage you from asking any questions. I know the technical rules are that Q&A is not supposed to be included, but I tend to think that if a question arises, I've tried many jury trials and frustrated a lot of court reporters because I can go about as fast as I want. So if you ask me a question, I assure you I do not intend to go over the 2 hours that we set aside here this afternoon. This is a little overview of the office. It's important for me, but it's also important for you and for the public that we serve to see exactly what we're doing. And it's also important right now because I just met with Justice Castle yesterday. One of the prime things, if not the prime thing, was to get my office into the 20th century. And note, I did say 20th century. I did not say 21st century. Our discipline history is now physically kept on a Rolodex. Actually, 2 Rolodexes. I don't know, those of you that took Latin, if that's Rolodi, but our discipline history is on Rolodexes. And we always have to be sure when an attorney calls and wants to motion in another state, I go to pull the card. I've been cautioned that I need to shake the Rolodex holder and then dig down under the cards just in case someone's card might have fallen to the bottom, and that's a technical thing that we have to do at our office. Very, very, very highbrow stuff. But this is the whole process that we go through. I am basically intake. We are not Colorado. We have about 7,000 licensed attorneys in the state of Nebraska. Well, 9,700 attorneys admitted. I think that's a little high because I think that includes inactives. And that number, by the way, has only dropped with the change in the setup of our Bar Association because the inactives are resigning like mad for whatever reason. And that's unfortunate. But Colorado has 40,000 licensed attorneys. They have a staff of 40 attorneys. I have myself, John Steele, who's been out ill since December, Kent Probish, and then we have Jane Burke, who used to be here doing UPL, and she's working part-time to try to help us keep up in John's absence. So I am intake. It comes before the grievance letter. People call and complain. And those of you that work in state government get those calls too. They call and complain about anything from their lawyer, which is what we're there for, to the dog catcher. Depending on whether their meds are up to speed or not, we'll get repeat calls from the same people about the same time every month. Some of those just go away, and we call those miscellaneous. You attorneys wouldn't even know that I've actually written your name down on a piece of paper, or actually even wrote a letter with your name included in it. And that's to your benefit, because that isn't even getting to a level of a formal investigation. We do not take phone call grievances because we try to give you the benefit of the doubt. We do give you the benefit of the doubt as Nebraska licensed attorneys. And we require them to actually file a physical letter. Colorado is pushing the envelope. They have 2 lay people that do nothing but take complaints over the phone. And they initiate investigations based upon an oral complaint. Dennis's philosophy, and I tend to agree, we're not going to do that. We want the people to know how serious it is, and they need to take the time and get me a letter. Now, that letter can go one of 2 ways. It can go as a 9C, which says basically under the rules, even if what they say is true, it wouldn't warrant discipline. Pick up the phone and call your client. Let them know what you've done on their case, or let them know that nothing has happened. You make peace with them, which you often do. I will say most of the time you do, and I dismiss it. And it goes away. There's no appeal of a 9C dismissal. Unlike a grievance, that if we do proceed with it, we can either file a complaint, but if we dismiss it, it then can be appealed to the disciplinary review board. And I will say most of the time when we dismiss those appeals, they don't go anywhere. 90+% of the time, the DRB will affirm what we've done. And likewise, if we file a complaint, it has to go through the Committee on Inquiry, who then can proceed. If I recommend a private reprimand, they'll affirm that. I find it interesting, John Steele actually pointed out that a respondent does have the right to appeal that to the DRB, but that's probably happened twice in 20 years. And I suggest to you that if we thought you made a mistake, and we're just suggesting a private reprimand and the Committee on Inquiry or the COI affirms that, you might want to think twice about appealing because it could lead to formal charges. That's why you probably wouldn't want to run the risk of just take your licks and take that private reprimand. So we have lay people as well as legal professionals on the COI and the DRB, and the lay people are the ones that I will tell you from my experience will be the tough ones. And the first case I prosecuted because of John's illness, Dennis didn't prosecute, he hadn't for 20-some years. He relied on John and Kent to do that. The first one I prosecuted, it was tough for me, especially as a former criminal defense attorney, to put on that hat and actually go after someone, let alone a brother or sister lawyer. And I recommended a private reprimand. They soundly rejected my first recommendation, said they wanted to go after this guy. So we actually did file formal charges, and that matter is pending. You'll see these statistics from 2013. Those are being updated as we speak. Actually, we just got the final numbers in yesterday, found some mistakes. The most telling part, and I've got to get a better slide for next year, but the most telling thing is on the summary reports. In 2010, we started MCLE, and you'll see that since that time, and that continues into last year, our number of complaints has dropped. Someone from a law school out east, a student called on behalf of a professor who was doing an investigation into MCLE, and I know there was great resistance by our membership about MCLE because we hadn't done it. And he wanted to know if we had MCLE and if I thought, based upon our statistics, it had a positive impact with regard to attorney complaints. And I say, I don't think it's a coincidence that the numbers have steadily declined. And that number, that chart that I had hoped to have slipped in here today, will show an increasing decline again for last year, consistent with my theory that it's not just a coincidence. The grievance by area of, or length of practice, I apologize to the young lawyers out there, 1 to 5 years, because I thought going in last July that you young lawyers were the ones I was going to be coming after because you're out there on your own making mistakes, not asking the questions you need to ask. But no, I apologize. 21 years in practice and above are making the mistakes, which raises the issue about should we be allowing our older attorneys to skip MCLE when they reach the age of 70 or 75. Our attorney emeritus and exempt on MCLE, what is it? I think it is 70. Attorney emeritus is 75. Why those aren't the same, I don't know. But it does raise an issue about why we should be letting our older, experienced, seasoned attorneys off the hook. Grievance by district, big deal. You know, between District 2 and 4 and 1 are the big complaints, but those are the most populous. This is an area I'm going to work on with the ABA audit. They want us to automate, something I touched on earlier with the Rolodex. No big surprise to me. Family law, estate, probate, and criminal are the highest ones. The one highest by volume is something that means nothing to any of us, certainly doesn't mean anything to me, and that's the highest one is the other category, which I say it's got to be somewhere between admiralty and zoning, and if you're doing either one of those, you probably don't know what you're doing anyway because nobody does. So we're gonna try to make that number. You know, immigration is in there. Any number of other things that needs to be pulled out so it means something to us. This is a letter no one wants to receive, but if you're not practicing law, you're not going to receive it. In government practice, you're probably never going to see this letter unless you're a volunteer like me on one of the committees. Dennis always thought it was fun to send those letters out. Save money, but send this letter out, and I'd get it with the confidential deal on it and freak out, and it'd just be the new roster of members of my committee. I told him to stop doing that, and he never did. But he just thought it was fun. Some of the things won't change. This is the serious letter. It's pursuant to Rule 3309E, and that is the big one. Sorry if you get it. It's not the end of the world, but you do need to stop and pay attention. And as John Steele would say, you better take it seriously because our office does. And the reason you'll know that it's serious if red stamp, but it's not certified, take a breath. It's either, you know, good, congratulations on a good result that I just read about in the paper, or here's the roster, the updated roster of your committee. If it comes certified, it's not going to be one of those. So that's where you want to move your hearings and drop what you're doing. I can't stress enough, when you get this letter or the one that's not so serious, the one pursuant to 9E or 9C, you pay attention to it. Have somebody else look at it. Don't address it on your own. You should never be in a position in your practice, and that's why I think they call it a practice, to think you know everything. Have another set of eyes look at this. If you're in sole practice, call a mentor or a friend in another firm, whatever. Have somebody else look at it before you just send it out. Dennis would just send a letter that says, pursuant to 9C, we're conducting a preliminary inquiry. I've decided that I'm going to give you a little guidance, and that's why you see the blank lines. I'd say I really would like you to look at these allegations. If you haven't received one, good for you. But when you do receive one, some of them are going to go on forever. And some of them are repetitious from complaints they'd file about their attorneys, you know, months before, and it had been resolved and dismissed. And then they may raise the same thing over again, which I'm not going to look at again, and add a couple other things. And I may say, just ignore everything but these two issues or this one thing and get back to me. This one, I can't, again, stress enough, even if what they say is true, it isn't going to warrant any big whoop action against you. Talk to your client, make it right, you know, convince them to dismiss the complaint, and you can go to fee arbitration if they're fighting over a fee. And I'd strongly encourage you, if there's a fee dispute, not to take the high and mighty approach, but to try to resolve it with them. If a complaint has not been filed, you can take advantage of the fee arbitration process through the NSBA. If the complaint is filed, even if it's a 9C, you can't be eligible for fee arbitration. But frankly, they don't need the extra work over here. They've got plenty to do. You should be able to resolve your differences on fees with your client before it even gets to that level. I'd hate to see a fee dispute end up a complaint, but it will. Not just a 9C, but I'm saddened and surprised at the same time at how many people, including former colleagues and friends and classmates, get that 9C letter from me, and they just blow me off. And one of the reasons, yes?
Quick question.
Yeah.
So you mentioned there's a fill in the blank spot on that letter, so you say specifically look at this issue.
Right.
For the other type of letter and for this one, are the complaint letters confidential, or does the attorney get more information about what specific complaint?
Oh, that's a good question. When to repeat for those of you online, what do you receive when you get a letter, a 9C or an E letter from my office? And it's not a two-way street. If it comes to a letter, either the C, the not so serious, or the E, the very serious, I will send you everything that was sent to me, unless there is some reason that they set forth that it would be confidential, which I can't imagine it would be. But you're going to get a copy of everything. Now, when you respond, you may not be the client. You may have information that would be privileged under some scenario, or you may say, I'd rather not reveal this information because it's just going to really hack my client off, and we won't include everything. On a 9C response, we don't even have to give your response to the client. We've determined, though, I should say the complainant, your client, we've determined, though, it is much better if we can provide them with some ammo that you have that says, look, he's saying I didn't do anything on the case. Number one, I'm going to look up the case on justice and determine what you've done and back you. I'm going to look at your bill and see that the time that you did spend the time on the case when the client usually alleges that you've done nothing. I mean, that's the complaint I received when I was doing criminal defense. It's a complaint I see in domestic and criminal cases, which are the bulk of the cases against us. Does that answer your question? Okay. Now, maybe some of the things on the ABA audit I should talk about. Obviously, the automation is the big deal. We're going to get into case management software, which we don't presently have. We're going to go paperless, all the things that we were in the process of doing when I was in private practice. We're going to get the attorney history loaded per attorney, so every licensed attorney will have basically a file in this new system we're looking at. When people call in, everything related to that file, from emails to voicemails to phone calls, will be logged and will go to that file. Now it's all manual. It's very tedious, and with John out sick, I can't even look and see what he's done on a file unless I actually physically pull it, which makes it impossible when sometimes I'm the only person in my office of 3 attorneys and 1 administrative assistant, and I can't get up and get that file to answer that question. It just doesn't make us look as professional as we perhaps should. One of the criticisms from the audit is very surprising, but it's just to me, you know, it's the hot shots from Chicago and New York that don't know what it's like to be in Nebraska. We don't want you, this whole thing promoting just call Dennis, which we all, most of us, grew up in our practices knowing that we could do. It could be confidential. You didn't even have to identify yourself other than saying I'm a Nebraska lawyer. ABA says, well, we'd rather you didn't do that. And the reason is, in our litigious society, I presume, that they feel that a potential respondent would be calling asking for ammo to be able to use it as a shield because they know a prosecution's coming. That's never happened. I should knock on wood, but I don't think it will. And as we automate further and document when you call, we'll be able to track, in general at least, the advice that we give. And I don't think, we would say too, if you want something more than just a casual, this is what I think, look at this advisory opinion, the kind of stuff I do every day. If it's more serious than that, I'm going to tell you to get an advisory opinion. And I don't know that we've ever prosecuted someone for following an advisory opinion. In my opinion, that's for the Supreme Court or Court of Appeals to do, to say that, you know, Weber's opinion from 2004 does not follow our reading of the rule, and we overrule that advisory opinion. So I would use the advisory opinion route as a shield. That's the same way, too, some of these recent opinions. It's amazing how much that part of my world for 10 years is now part of my life every day. But it does help me to find something for an attorney very quickly when you might have a question. If we don't have the answer, I usually will find it within about 20 minutes on the ABA website, which you can go to and search. You can also search our advisory opinions. I'm somewhat amazed. Again, it's probably not fair because I served on that committee for so long. On the supremecourt.gov website, if you go down the left-hand side, you'll see attorney services. You click on that, you go down further and look for Counsel for Discipline. You click on my site, there's a link to the advisory committee so you can see who the members are, including the chair, and you'll see a searchable area for ethics opinions. And it works fairly well. But if you can't find it, don't worry about it. Just pick up the phone and call me. That's why I'm there. I'm just going to go through a few advisory opinions that I've pulled out. These probably are more geared to the criminal defense side. Sorry for those of you that aren't in that area, but I think you might find it interesting. Some of them cross over. One of the interesting things really is whose file is it, that I thought was pretty clear, but many, many attorneys don't think it's very clear. So when you call and say, hey, I need this answer tomorrow because I want to do this, it doesn't work that way. These guys are practicing law full-time. That's their regular job. It's an unpaid position, and so we require detailed information. And the rules provided that if you, number one, a member, I just turned someone down today from Ohio that thought it'd be cool to get 50 advisory opinions from 50 states because they want to do a cloud-based attorney service through the United States. And I said, well, that's great, but we're probably not going to look at it because you're not a Nebraska licensed attorney. And being the smart lawyer that he is, he said, well, what if I get a Nebraska attorney to make the request? And I said, well, that's a good way to do that. But it's not that simple. You don't just pick up the phone and say, hey, give me an answer to this question and write it out really nice. We require you to do all that work. And the rules basically say that you're supposed to cite to the rules of professional conduct and any case authority, and you can use any advisory opinions from across the United States. If you are an ABA member, you're entitled to search all 50 states for their ethics opinions. And you can use case authority. Again, it's better if you can use Nebraska, but if we don't have anything on point, then you go to other states just like you would in a brief. We're now requiring you to go a step further, and why not? We want you to draft that advisory opinion in the format of an actual, your request and your proposed result in the form of an actual advisory opinion. There are a lot of reasons for that. Number one, if you're advocating for a position in an area of ethics, we would think that you would advocate for it in your favor while pointing out some potential pitfalls or other jurisdictions that might not agree with you. But also it moves it along. When I was first on the advisory committee about 10, 12 years ago, we had some opinion requests that would take up to 12 months or more. And now, when I left that committee last fall, I'm happy to say that we usually get something out within 60 to 90 days, 6 months perhaps at the longest. But you can't call and say, I'm selling my practice tomorrow, I need an answer. It's not going to happen. I do get calls that say, look, I have an advisory opinion request pending. Some of these conflict issues I'll get into. I've said, well, look, we know that an opinion will be out in the next several months. Disclose, disclose, if you get approval, I'm not going to prosecute you for something that the advisory committee comes out later and says, well, you really shouldn't be doing it that way. I'm going to move through some of these related. The calls about files, it's unbelievable, come through repeatedly because the lawyers tend to believe that it's theirs, and it's not. But this one related to person appointed as a trustee, and that we don't have counsel through the state that are appointed to take over if someone's disabled or deceased or otherwise impaired from continuing to practice. We appoint a trustee. In this case, the poor trustee, she was finding original documents, wills and birth certificates, etc. What do I do? Well, 88.3 said we can't state with any certainty when you can destroy a file. The old "it depends" response. Well, I was on the committee back in 2012, and now we've got the rule that we pretty much did it in line with our trust account rule on records. 5 years is the cutoff. I mean, so many things are saved now to computers, et cetera, that we're not going to require you to maintain those records into the future. I would say, though, knowing that rule, I would make it clear in your fee agreements or in your separation letter. Been great doing business with you. Glad we served you. Come and get your file. If you don't get it within 5 years, it will be destroyed, and then destroy it. We had one attorney retire, stored all his files in his basement. We now have his widow calling saying he retired 7 years ago, he died 3 years ago, we still have the files. If you kept them, you're going to have additional responsibilities in terms of destroying them. You know, I don't think it would be very well received if the client called and you said, yeah, I have the file, and they said, well, now I want you to go through it and get me all the good stuff that's in there, and you say, well, it was over 5 years, so I destroyed it. I wouldn't do that. Question that arises with respect to files, and I think that's coming up. Whose file is it? Your fee agreement says, you know, I can keep your file until you pay your bill. Well, that's great. But if the client needs it, in circumstances where the client's continued representation would be in jeopardy, and guess what the client's going to say after they've fired you? They're going to say, my continued representation will be in jeopardy. And they'll call me and tell me that. Well, I'm not going to come out and investigate it. I'm not going to go through the file. I'm going to say return the file and worry about your civil remedies to get paid later. You must assume that the client is going to need the file, even though you know the client doesn't need the file. They can otherwise get it on justice, or they just don't need the stuff. And they know once they get the file, they've reduced your ability to ever get paid. That's unfortunate. But I actually have to say that I lost my temper recently with an attorney that I asked nicely to return the file, and she refused, and it led to a follow-up call. You know, either return the file or I'm going to seek to suspend you, because I will consider that continuing harm to the public if that's the course of conduct you're going to maintain. So you can write your fee agreements any way you want. In the end of the day, you owe that file. Another question that arises is, well, wait a minute, I already provided the file, and I have proof that I provided the file. It closed, please, fine. I did it every time. You only have to do it once. If you're a nice person, you can volunteer to do it again, but at your leisure and in the manner in which you want it. One called said, well, I put it on a disk. I don't want to give up the hard copy. If that's the first time the client has had copies, you can't do it that way. You got to give them the hard copy. You can keep the disk, but if they destroy it, the dog ate it, and they want it again, they have to pay for it, and I'll back you on that. Some of these lead into the criminal defense area, and that's why I put them in there. This one was interesting to me as a former part-time criminal defense attorney. This poor guy, a Nebraska licensed attorney, who was a lieutenant colonel, as I recall, stationed at Guantanamo Bay, was appointed to represent someone involved with the 9/11 attack. found out that the smoke detector wasn't really a smoke detector, it was a listening device. And he's pretty upset about it, but he wanted to know his ethical responsibilities to his client, knowing that it was likely he was being recorded. And, in addition to all the other things, we realized that he had court remedies that I wouldn't think a judge, even in that circumstance, would be very impressed with a prosecutor's conduct in intercepting this. But if you disclose to the client that such things were happening and the client consents, then you can proceed and continue to represent the guy. Interesting thing is, advisory committee opinions are supposed to be confidential, and we issue those as formal if we think it would benefit the legal profession, the Nebraska bar as a whole, and we issue them as informal if it's unique to that person, or by publishing it, we'd basically out the person. Everybody would know who we're talking about. And in this case, we determined how many attorneys licensed in Nebraska are practicing in Guantanamo Bay. So I said, well, we'll issue it as a formal. He said, hell no. I want it as a formal. I don't care if they know. Basically, some expletives. Let them know it's me. I'm glad. So we published this. For the government types that I guess I'm part of now, this comes into question when we've got some budgeting issues, and 1305 dealt with an attorney working for the government. This came out of D.C., but it was a Nebraska licensed attorney, was being furloughed. She was asked to stay back because she was very talented, and the agency wanted her to continue to represent the agency in defending objections to furloughs by other agency employees. And she wanted to know if that was a conflict. Believe it or not, proud of this opinion, if that attorney subjectively believes that she can be fair in representing the agency, even in cases which might adversely affect her objecting to her furlough, she could remain in the case. And I thought that was a pretty good opinion. And frankly, that it was very consistent with an opinion out of the D.C. circuit, which got more of a. Another one, again, on the criminal defense area. This one was, again, on this idea of confidentiality. Everybody knew who made this request. I won't tell you right now, but Kentucky had frowned on waiver of bad attorney plea agreements, and had said in an ethics opinion, you can't require a defendant, basically asking for a waiver of negligence, can't require a defendant to waive appeal and ineffective assistance of counsel, or IAP as we call it, in your federal plea agreements. Kentucky had done it in an advisory opinion. Kentucky said no. And the interesting thing was that started in state court. It was a county attorney requiring such waivers. U.S. attorney got wind of it and appealed it, and the equivalent of our advisory committee said, don't do that. You need to abide by our ethics rules. And the U.S. attorney was upset in Kentucky and appealed it to the Kentucky Supreme Court. Be careful what you ask for. The Kentucky Supremes affirmed the advisory opinion, and that's what we did. And we said, don't do it anymore. Even after Eric Holder announced his resignation, and after Eric Holder said, get rid of the bad attorney waivers, the Attorney General, or I should say the U.S. Attorney in Nebraska, continued to enforce old plea agreements. And so we issued that opinion. I thought there'd be more fallout from that, but there hasn't been, and to my opinion. These are just recent advisory opinions, and this is all new to me. That as counsel for discipline now, as opposed to chair of the advisory committee, I kind of heard the cats on the advisory committee, which Dennis did with me. I guess I had the final say if I were totally against an advisory opinion. But this one is recognizing what's going on more and more in our country, and that is attorneys are moving all the time. You're not just like formerly with baseball players, you didn't play for the same team. This one leaves firm A to join firm B. The firms have been engaged in contested litigation for over a dozen years. I think they're on their fifth remand for the Court of Appeals on an estate matter. This guy had no involvement in the case. And we recognize, as I noted the case when I left my firm, we didn't know what half the attorneys in our firm were doing. It's somewhat frightening. But I was involved in criminal defense and civil litigation, plaintiff's work. We had banking, commercial, estate attorneys. I didn't know. frankly, I didn't care. I trusted my partners to be fair and do the right thing and follow the rules. We said that that attorney could go, as long as he had no involvement on the new with the new firm on the other side of the litigation. Makes sense. This one, a Nebraska lawyer he was elected as county attorney, wanted to accept appointments as GAL in adjoining counties. This happens all the time in our state, and I'm sure in other states, because we have smaller jurisdictions. People are in a part-time capacity, need to make a living, and this case just presented interesting ethical issues and wanted to be a GAL somewhere else. And can the other members of the firm do it even if that attorney couldn't? And unfortunately, the answer is no, because a county attorney needs to get a waiver from his client. And the county attorney's client is the state. The state can't be in a position to give a waiver. And that prohibition also extends to other members of that attorney's firm. But if you are a county attorney, you can accept appointments as GAL in private civil cases because the state of Nebraska isn't a party. So hopefully that makes sense. Now, this is one, and maybe I'm talking to somebody that was involved in this, but this is a part-time public defender wanted to be the part-time county, or a part-time county attorney wanted to become the part-time public defender and vice versa. And they wanted to know if that would raise an issue of conflict if the public defender was on the other side and was actually representing someone that she had formerly prosecuted. And 1503 says it's not a per se conflict. This goes back to that furlough deal. You have to subjectively look in your soul, but it's a two-part analysis. You know, you can imagine if there are some prosecutors in the room, you know, you can't help but, by representing the people, zealously prosecute someone, and you may end up calling that person some nasty names. You may have sent them away. And in a smaller town, everybody knows who the mean prosecutor is. And now all of a sudden that mean prosecutor that may have prosecuted you says, come on into my office, I'll now represent you. It's not just the attorney's subjective belief of whether she can be fair, because I know we all know that we can be fair. It's, wait a minute, you got to take a step back and say, client, I went after you. I may have put you away. You got to tell me, do you have a problem? And if they say they do, then you say, well, I have an associate. She'll take over. And if the client persists in saying, I don't want anybody associated with you involved in this, then you'd have to petition the court for appointment of a special public defender. Other pending requests, and somewhat of what we're dealing with as a national organization, this issue of diminished capacity is happening more and more with our aging population. And I jumped ahead a little bit, but the ethical obligations reporting diminished capacity of a partner. I spoke to the legal secretaries in Omaha a couple months ago, and I had a legal secretary melt down on me, raising all sorts of issues that she was covering for her attorney who had given her her first job and took care of her all these years. Well, that's a couple issues. She has a duty to report. If she's in a firm setting, you as the managing partner or as a sole practitioner, you as the sole practitioner, have an ethical obligation to ensure that your office, including your staff, abide by the rules of professional conduct. A lot of people don't think that it extends to the people in your office. It does. And it's a two-way street. That legal secretary has an obligation to call my office. Now, that doesn't mean that I'm going to run and file something and it'll all be public because it comes over here to Rick Allen and NLAP to do an intervention much like they would with drug or alcohol dependency. And they try to encourage the attorney to get the help that they need. But I say it's a double whammy because what's that legal secretary doing? She's committing UPL. She's drafting those pleadings or those letters, putting them under the attorney's nose, and they're going out without an attorney being the last person to see them. And we're not going to make a lot of people, especially in the family law area, happy when we start telling the attorneys, you can't have your secretaries or your paralegals even sign off on stuff and be the last person to see that out the door. Now, a letter when you're golfing in Scottsdale to the client saying, enclosed please find the brief we filed last week, that's different, in my opinion. But a legal pleading or answers to discovery that the attorney hasn't looked at it last before it gets filed, that's a whole other issue. And on that note, now that we're in the era of e-filing, it's going to be hard to figure out who looked at that document last when it's just that e-signature. I'm just throwing it out there, but those are things we're going to be looking at. This is one, the first one on the slide, the ethical ramifications regarding court-ordered detailed billing. The watch groups out there want our bills in full detail. As a former criminal defense attorney, appointed in many cases, including capital cases, I can give you any number of reasons why I don't want that detailed billing out there. If for no other reason than, sorry, county attorneys, I don't want you seeing it. I don't want you knowing what I'm doing. But like anything, we got a few alleged bad apples who may have ruined it for everyone. Billing 12-hour days on one file, incredible amounts of time in a week over and above what would normally be spent. And I blame the administration in the various counties for allowing this to happen. There has to be some insurance that the time is reasonable in connection with the work, but that's one that's going on, and this is actually a pending one, about what confidentiality is being breached here by requiring all this detail and what work you're doing on a particular file. And that basically is in the guardian ad litem venue. This is interesting. The one I mentioned earlier about the Ohio attorney asking for an advisory opinion. I had an attorney who felt he was on his way to diminished capacity, admirable that he would bring that up, ask if he could share an associate with another firm. He didn't have enough work to do, but wanted the help to transition his firm. And those of us in smaller counties know it's hard to get somebody out there. We're forcing our older attorneys to practice longer than they wanted because they can't get anybody to come in and take over their practice. Part of this request that I think is coming now, it was in the context of cloud-based attorney services. They want to share associates between firms. So I think this two firms sharing an associate or more than two firms sharing an associate is actually going to be addressed probably yet this year. All right, moving quickly, the next presentation on social media isn't that long, so it really isn't going to be 2 one-hour increments. And we talked earlier, I'll get through this ethics in criminal practice, and then we'll take a break, and then I'll engage in my flying if necessary to land precisely on hour 2, so you guys can keep your schedules. This is a hot topic. I'm actually going to be on a panel, and not because of my expertise as counsel for discipline for 8 months, but as maybe a criminal defense attorney for 30 years, bringing the defense attorney's perspective into what my office and the offices across the country should be doing with regard to ethics in prosecuting criminal cases. I can tell you that just practically, I follow Dennis's lead, and I come into the office every morning and I scour the World Herald and the Lincoln Journal-Star, and it's amazing what I pick up about my colleagues in the practice. It's that high-profile criminal trial, prosecutor and defense attorney are fighting, and it gets reported. There's one example I'll give, and apologies to my friends if one of you, either the prosecutor or defense attorney, are involved. I will say I didn't prosecute it, but I read it with great interest, my eyebrow raised. One attorney says to the other, "You're a liar." The one says back, "No, you're the liar," and that's in front of the jury. And the judge tells them to knock it off. The defense attorney loses his temper and says, "That's not fair." Prosecutor says in front of the jury, why don't you just shut up, little boy? You know, we need to keep our practice on an adult level. That's easier said than done. When you're in the heat of battle, trial attorneys out there know exactly what I'm talking about. But I'd like to think they'd be like the old days where you're close to slugging the prosecutor or vice versa, and then you walk out and you go have coffee or beer together after because you did your job, you did it well, and you moved on. And you did it within the bounds of our rules. The hottest issue, obviously, in the criminal defense area is disclosure of evidence. The gist of what I'm saying, and I'm giving credit to my colleague and friend, former colleague and friend Denise Frost, who presented on this with a former Douglas County attorney. The gist of this, if you take nothing else away from it, prosecutors out there and also defense attorneys, is your ethical obligation is actually greater than your legal obligation. Produce it. I know of a county attorney who once said to the police officer, if you don't want me to see it, then don't give it to me. Well, okay, that's about half right, okay? If it involves this case, I need to see it and you need to give it to me because I have an obligation to turn it over. I firmly believe, and again from private practice, whether civil or criminal, your discovery obligations far exceed anything that would relate to what is relevant evidence in a court of law. What is discoverable is much wider, a much greater pond than what might be admissible. The obligation, and this is in the United States Supreme Court cases, basically your obligations under Brady are as great whether the defense attorney doesn't make a request at all. I always, you know, it bothered me, I have to say, it bothered me in law school, probably still bothers me today, about that rule that said when you're aware of that one case that absolutely annihilates your position, you have an obligation to turn it over to the other side. Well, wait a minute. In law school, did I have an obligation to make sure that my peers were as prepared for an exam as I was? I have a hard time with that, I must say. But that basically is what this says. You've got to give it to them, even if that attorney that isn't doing her job out there as a defense attorney didn't even bother to ask you for it. It starts with the United States Constitution, and it basically comes all the way down to our Constitution and our state statutes. And that's the general request that I must say I just cut and paste in every case. Having something on file as the defense attorney certainly bolsters your position when you find something out later in your motion for new trial for newly discovered evidence on something you deem was exculpatory. There are special ethical rules for prosecutors. It's right there under 3.8. Timely disclosure, anything that might tend to negate the guilt or mitigates the offense or might have something to do with sentencing. That might be mitigating. And I'd have a hard time as a prosecutor holding on to anything, honestly. But you're a minister of justice and not just an advocate. Basically, and maybe I was a different, I know I was a different kind of criminal defense attorney, but I firmly believe, as hokey as it sounds, that the law enforcement, of whom I have many friends, the judges, of whom I have many friends, and the prosecutors, we, law enforcement, judges, prosecutors, defense attorneys, we're all a team. We all had one goal, and that was to see that justice was served. How can you live with yourself if that guilty person gets out? Well, I live with myself very well. It's not my job to prosecute the case. We all had our roles to play. Shame on you defense attorneys that were afraid of a serious case because people didn't like you or called you names or might have threatened your life to not do your job for that client. You just saw in the paper. I'd like to know what the disciplinary counsel in, where was the man shot while running away 8 times? Yeah, what's South Carolina. Attorney comes out on Facebook is kind of his shtick. I am a young lawyer, I'm aggressive, and I get big cases, so you should like me. And then, hey, I represent this guy accused of shooting this man, and I think you need to give him a fair shot at this bad use of words, then sees the video, and then goes out on YouTube and says, I saw the video, I'm withdrawing, it's horrible. Well, he really didn't think about his client when he made those comments, and actually probably removed any chance of this guy getting a fair trial, as much as he deserves it, regardless of what it looked like he did on video, which I think we'd all agree doesn't look very good. 308 continued. Again, that's very similar. Tends to negate guilt or mitigates. It is, tend to, is very broad. I think you'd want as a prosecutor to err on the side of turning everything over. And if, as a prosecutor, if you really have a question, go to your superior or go to the final authority and have the judge make an in-camera review of it. Make, claim a privilege log of some sort, whatever you think. Brady Standard looks backward. Whatever's material, if it had been disclosed, the results would have been different. Again, reasonable probability, likelihood that the different result was great enough to undermine the confidence in the outcome. It isn't more likely than not. But Nebraska is even more forward-looking, and just in general language, the strong indication that it played an important role. I mean, my goodness, why wouldn't you turn everything over? That goes without saying. The United States versus Darwin Jones, the defense is by definition unaware of exculpatory information that hasn't been provided. Duh. Now, some of these aren't the fault of the prosecutor, and I experienced this in Douglas County after the big pensions were kind of rolling to an end, and we saw our very, very capable and experienced officers take early retirement, and we had young bucks in cases that they were, frankly, perhaps over their heads, especially in the sexual assault and homicides. But they're also overworked, and the idea again is who are you really working for here? The prosecutor tends traditionally to say that we're backing our cops here. And we're seeing, unfortunately, the net result of that nationally in some of these unfortunate instances where the prosecution isn't going after or properly presenting matters to a grand jury, for example. Again, you use the federal rules and use the local rules of discovery to get what you need. And then the Massachusetts motion. And I can provide these slides basically, but it's under 608B of the Federal Rules of Evidence and other things that the government needs to disclose in its case in chief. As I said before, the ethical duty is greater than the legal duty. While the potential prejudice to the defendant may affect the severity of the sanction, it should not affect the initial determination whether there's been a violation of the ethical code. This is one that I've actually had a call from a couple of defense attorneys involving the same prosecutor, where the prosecutor pushes for a plea agreement prior to trial. Defense attorney doesn't think that she has the evidence. You've got to take this deal last minute, or I'm going after the whole deal. A lot of anxieties. We know if we represent a criminal defendant, should I take this deal and get out with a lesser charge? And then the day of trial, when they refuse to take the deal, she dismisses and does it repeatedly. This one, he acknowledged, the prosecutor admitted months before the trial, he knew he didn't have enough for a conviction on a charge, and yet months later still talked about it. Well, he admitted that he couldn't prove it in an opening statement, but he still talked to the jury about the charge. It was still part of the charges against the defendant. Interesting language. This was just a year ago from State versus Rodriguez. They reversed for other reasons, and they fairly strong language because there's no reason for the state to engage in the same conduct on remand. I think that's a little finger wagging there by the Court of Appeals, if it was the Court of Appeals, and then our disapproval of the state's conduct. Well, that's something that Dennis would be looking at. And we read the Court of Appeals and the Supreme Court opinions just like we read the paper, and we might initiate an investigation based upon fine and closed article or fine and closed opinion. Why don't you talk to us about what you were thinking, what you were doing? Those are probably the more likely times that our office will get involved. A criminal conviction obviously is a slam dunk, whether you're a prosecutor, a defense attorney, or a licensed attorney. We'll probably be asking for an explanation. Best for the defense, always file your motion. For the prosecution, I would say you're much better off providing it, or at least having a court do in-camera review, than answering a letter from my office and explaining yourself. And I landed that right on the hour. While I switch over, why don't we take 5 minutes? And I promise we will be done by 3 with social media. All right, here we go with Chapter 2. Bear with me. I've presented quite a few. I think I'm at 32 weeks or so and counting, and I know I've presented just shy of 40 times. But this is the first one I've gone to half marathon of 2 hours. Usually my presentations are an hour, sometimes hour and a half max. This is one I presented to the Leadership Academy in Omaha a couple of months ago. They'd asked me to speak on the ethics of social networking in the law, kind of a fascinating area. I want to give credit where credit is due, avoid potentially muting our guests. Elizabeth Clark Tarbert, my colleague out of the Florida Bar Exam, had this presentation together, and she asked me, or she encouraged me to go ahead and use it. I modified it in many respects, of course, to comport with Nebraska rules and Nebraska case law. I'm going to start out by saying, you know, everybody's like, oh, this is new, cutting-edge stuff, Facebook, Twitter. Gosh, have the ethics caught up? Well, to quote Robert Fogum, everything you ever needed to know about life you learned in kindergarten, the ethics haven't changed. Those rules are all the same. And a lot of what you're going to see in social networking in the law basically parallels what we've already come out with respect to advertising. For some of the older folks in the audience, we know that that advertising aspect was really frowned upon. Even when I started in the late 80s, it just was something you didn't do. And it was unsavory. It wasn't really fair. You know, if you had more money, then you could advertise on TV, and then you'd just make more money. It just didn't seem right. But as you know, when you travel, especially places like Arizona, when you're watching TV after 6 o'clock at night, all you're seeing are ambulance chasers, of which I was one, so it's not like I'm picking on my colleagues. I actually started out doing criminal defense and insurance defense, and then my mentor, Joe McQuillan, said at some point about 15 years ago, I turned to the dark side and I did nothing but criminal defense and plaintiff's work. So I'm not impugning any area of practice by any means. So social networking in the law. Some of the things we'll cover today. Sarah, did this get shut off? There it is. All right. Communication with and investigating witnesses, communication with represented persons, social networking and judges, social networking and jurors. A big one for those of us that did criminal defense or prosecution even, trial publicity, creating the inadvertent lawyer-client relationship, confidentiality, and then advertising and solicitations. You cannot contact anyone, and that's 4.3 of our Rules of Professional Conduct. You can't just say, I'm just looking into this. You have to make full disclosure. And that goes whether you're online or just on the street or over the phone. The old rules that we prosecute, you can't be involved in conduct involving fraud, dishonesty, deceit, or misrepresentation. And cannot do indirectly what you can't, you cannot do indirectly what you cannot do directly. You can't violate the rules through another person, your associate, your clerk, your private investigator. Again, it goes back to that rule, as a supervisor, you have to ensure that everyone in your office follows the rules. Basically, you can look, but you can't touch. You can go to the site, and we normally would do this if we were defending a lawsuit about the person that says that he can't do anything anymore. He was so horribly injured by your accident, and then you see that he was out at a wedding reception doing backflips. That's open to everyone. But you can't offer to be the person's friend. Now, you can't go deeper and you can't ask to friend someone, but that doesn't mean the stuff isn't discoverable, and that's what you need to tell your folks. And I think we get to this a little bit later, but it's something that comes up. Can you tell your client to destroy everything within their social networking site? The answer is no. You may not ethically do so in the course of pending litigation. Can you advise your corporate client, your personal clients, that they should set up an auto-delete function after so many days? Absolutely, if you're not involved in pending litigation. So just be sure that you don't destroy something if it's something that might be discoverable and you're in the course of litigation. That's a big no-no. Now, New York has an ethics opinion that says you may make a friend request to an unrepresented person, but I don't think we would agree. I think we'd have to clearly require in Nebraska that you tell people that you are, who you are, and why you're there, and what the purpose is. That makes sense. New York says you can't create a false profile to obtain information or to make a friend request. I think the key in this in social media is don't get involved in making friend requests with any possibility that it ends up in litigation. And again, what we said before, you can't do indirectly what you may not do directly. Don't use your clerk or investigator to obtain information. That's an ethics opinion out of Philadelphia. You know, it's the age-old adage. You want to call the other side. Why would you contact someone that's represented in any fashion, whether it be by phone or social media? And again, that goes for your law clerks and your investigators. And that rule we'd already stated before. You can't violate the rules through another person. But again, it states the obvious. You can obtain everything that's available on a look-in that anybody could do. But once you make that friend request, you're basically putting yourself in a no man's land of possibly, and I'd say probably, misleading the person. And you're going to gain an advantage that you ordinarily wouldn't gain if you were open and upfront with them. Again, act as if you're just meeting them on the street. You wouldn't walk up and just say, hey, would you happen to know anything about X, Y, and Z, without telling them, I should probably tell you I represent the other side. We think you might be a witness, and give them the opportunity to say no. Basically, I have the perception that anything involved with social media is fraught with abuse and fraud from the beginning, so I'd just say stay away from it. Other than, why wouldn't you just get involved in your litigation, just subpoena the stuff, and they'd have to give it to you. And this New York sub-opinion says you can obtain everything on someone's profile, which if I were in private practice, I'd be telling my clients not to be involved in social networking at all if they ever had any idea that they might be sued down the road, because it's all going to be out there, the good, the bad, and the very embarrassing. Now this, again, it's what we talked about before. It's the San Diego ethics opinion. You know that these people are probably going to be witnesses, and so why would you ask to friend these people? And especially in that case, it was clear that anything these employees said would be possibly imputed to the corporation, or they have a parent authority who could bind the corporation. You just got to be careful on that stuff. And I think, other than just live looking in at a site, I don't think you should go further, other than perhaps with a court order. And actually, there was a provision in the rule that one of the ethics professors at the Nebraska Law College called, and it said that you could never contact an opposing party except with a court order. And he wanted to know what context would that ever come up with? You know, how would that ever arise? That you would actually go to court and you'd be disclosing it to the attorney. Just, I can't even imagine. Well, I think it found, the origins of it were found out on the East Coast where there are a lot of class actions instituted. And for the firms that were legitimately seeking to help potentially injured people, employment matters, mass tort litigation, that would contemplate, you would go to the court and say, I intend to sue Merck, but I want to be able to talk to Merck employees about their practices, if it was a bad drug, I want to talk to certain scientists about what they did in drug trials, or if, say, it's an employment discrim area, to see if they had a practice. I want to be able to contact people to see if they were treated this way. Very limited circumstance. I really don't think that that would ever come up. Frankly, I think that exception here in Nebraska is not even a real legitimate one that would ever be used. Frankly, I think even if you could legitimately use it, I can't imagine a judge that would allow you to. Take the person's deposition. They're represented by counsel, set it up with them. Again, common sense, and you know, our state is different because our judges don't run for office in the sense of voting. The judges shouldn't be friending lawyers who appear before them. Makes sense. You know, you remove the appearance of impartiality. But this one, I found it curious in the judges' election committees. They can use social networking for campaigns, and the lawyers can list themselves as fans. And we'll see something a little different about social media and the opposite of fans and judges here in a minute. This one out of North Carolina, the judge received a public reprimand for communications with an attorney, and it was a matter pending before him. You know, shame on the judge. Should point out, maybe you don't know this, but a lot of complaints we do get involve, criminal case would be the best example. I want to complain about my defense attorney who's rotten. I want to complain about the prosecutor who's rotten, and even worse, the judge who's even more rotten. We do not prosecute complaints against judges in Nebraska. That's done through Corey Steele, the state court administrator. On that note, I should also point out, you might find this interesting, by rule, we do not get involved in complaints on pending criminal cases for court-appointed attorneys. And that's both in state court and juvenile. Of course, it's not criminal, but we don't get involved in those. We also do not get involved in any pending or former federal criminal matter. And remember that advisory opinion I talked about with respect to telling the U.S. attorney, leave us alone on those plea agreements. I thought the chilling effect of that would be something that would encourage the courts to question whether they should be telling us to stay out of the federal business. Because now a complaint against an attorney in federal court, U.S. attorney or defense attorney, is handled by the courts internally. A recent example of where we both would get involved at some point was the attorney involved licensed in federal court suspended pending criminal charges. And upon conviction, obviously we stepped in, and that attorney voluntarily surrendered his license. Just a little bit of a insight into things we don't do. It was interesting, though, and Dennis was talking to me about this, said, well, you'll find it interesting, we're not to get involved in anything involved in pending or former federal cases. And he said he called the chief judge and said, well, I just want to be clear, do you want us to stand down in immigration cases? And the judge said, no, you go ahead and investigate those immigration cases. Public reprimand, and okay, and this one, you can, New York and Ohio permit judges to use social networking sites. Again, I'm assuming that might be related to the election side of things versus the appointment here. We would not agree with judges friending attorneys on social networking, I would say. I don't know that I'd just per se prosecute if I knew Bruce was friending his judge friends. It'd have to be something more than that, or I think I would wait for an advisory opinion, but I just think in Nebraska, It's just better if we leave the judges alone and communicate with them privately. We could certainly socialize, etc. People might argue, and I guess I could listen. Isn't that what social media is? You're socializing, and why is that any different than, or isn't it safer to do it on social media where everybody can see it versus the golf course and the men's card room where nobody can see it or hear it? So I'll keep an open mind. Mediators, makes sense. They're in the process of trying to do a business. They want to have a site. You know, my friend Mike Mullen has a great site that includes his calendar for all to see, and he wants to make himself accessible, and he is 7 days a week. The guy, crazy, is working so hard. But this one, out of the mediator ethics opinions, and I assume that's a national organization, I'm just guessing, or would have said otherwise, but go ahead and friend, but you're probably going to need to disclose that down the road, and it may disqualify you because the other side knows, oh, you're friends with that lawyer. Well, my lawyer isn't friends with him. I don't know that I feel comfortable with you being the mediator, which means you're supposed to be totally independent. So I just caution people about using it and what that may mean. Now remember how you wanted to say this judge is great and everything? You shouldn't go after a judge on social networking or social media. I mean, I don't think you needed me to be here to say that. That's probably just a bad idea. And then it goes both ways, though. A judge or a lawyer who's a candidate, you got to follow the revised code of judicial conduct, and that's as if you were going to be a judge. I found that interesting. But our rule says don't impugn the integrity of a judge. And an example, somebody called the judge evil, unfair witch, seemingly mentally ill, ugly, condescending attitude. She is clearly unfit for her position and knows not what it means to be a neutral arbiter. Nothing honorable. Boy, again, you post that out there, it's very difficult to unsend, or as we used to say, to unring the bell. And that went south for an attorney in Florida, and as Facebook noted, Facebook did, the Sun Sentinel down there, Facebook did, he gets assistant state attorney in hot water. Probably just bad advice or bad idea to do, whether it's on social media or with the newspaper or radio and the person, when the person's interviewing you. This is already in our rules. A lawyer should not seek to influence a judge, juror, prospective juror, or other official. And again, like I said, the ethics rules don't change. We just adapt them to whatever venue we find ourselves in. And you just cannot use social media as a means to get around that. I mean, it just, don't talk to a juror. It doesn't change just because you happen to have that iPhone with you. Much like with a witness, you get your possible jury pool, which some counties will give you and some won't, I know. But have your law clerk or your investigator go and look at their homepage and see what they're really about, in spite of what they may have asked or may have answered on a juror questionnaire. But you can't go any deeper than that. Just the same as what we talked about with witness. It wouldn't be any different with a juror, and that makes sense, doesn't it? If you do come into contact with a juror or a potential juror, or see that they did something inappropriate, you obviously have to bring that to the attention of the judge. I mean, it hasn't changed from 25 years ago when I saw one of my jurors in a slip and fall down in the law library. Now, what's he doing down there? He doesn't have any reason to be there, especially since he's in an ongoing trial. And I'll point out I was the second chair in that trial. The lead attorney said, "No, I like him anyway, so let's not object to his continuing." And boy, did we get hit. We found out later, we even questioned him. He was investigating the city code applicable to our case. This leads into something I was talking about, researching information on the internet, talking about a trial. And this one, humorous, friending a defendant in an ongoing trial. The juror and the acute firefighter. The firefighter was a witness, and the juror was looking him up and found his page, and she asked if he'd be interested in dating her. That was not a good idea. During the trial, I suppose it would have been fine after. Yeah, and then this one in social media and jury duty, a bad mix. That's a good article. And by the way, we'll make these slides available because I am flying through those to the extent that any of you here or online want to look up some of this stuff. But the one on the social media, jury duty, a bad mix, is a person texting friends to see how they'd vote on a particular, for a verdict in a case. Trial publicity, that again hasn't changed. I think some of us would agree there appear to be two rules out there. One for some attorneys that feel that they can call a press conference at the drop of a hat, and then the rule that applies to everyone else that says not to do that. You know, you try to provide the questioner with truthful information about the status of a matter. You can't use media, social media, or the live media to get something out there that is untruthful or that might prejudice an ongoing trial. And what we already knew, and you guys knew this before I even started talking about it, social networking is a public statement. And that's per Florida rule, and I believe Nebraska would feel the same way. You can always talk about the procedural posture of the case, where it's at. I guess I'd get to the point where I'd avoid talking about the merits of the state's case if I'm defense counsel, or certainly as a prosecutor to say, boy, I wonder what they're going to try to come up with. You know, you wouldn't want to do stuff like that. And inadmissible evidence, that's certainly something you don't want to talk about. Boy, I wish we could really talk to so-and-so, but he's taken the fifth. And there are sanctions, and I'm telling you from the prior presentation, we're getting pushed because the public is demanding it with these high-profile cases to look into abuses by prosecutors and defense attorneys alike in ongoing matters. And I think the same would hold true in a civil trial of any import. You know, the Keystone Pipeline would be a good example. If someone were out there spewing venom about a particular case and throwing out stuff that just isn't true, that you know, Keystone, I guess I better be careful what I say, you know, something like they know that's reasonably likely that the pipeline's going to burst every 5 years or something, and know that not to be true. That would be an example that you just shouldn't be doing that stuff. You may make statements that you believe are required to protect a client from undue prejudicial effect. Witness testifies, the people run out, you know, they have their cameras in front of them, and the attorney can come out and say, no, I think everybody needs to calm down. That's why we have a trial. We want to get to the end. Let's wait until we hear everything. We have witnesses we are going to call that will respond to this inflammatory stuff. And I don't think you're going to get into trouble with a judge or my office if you went to do that. But that's covered by 3.6b. This is the biggest thing, and it goes to the old adage of no good deed goes unpunished. That's the creation of an inadvertent relationship. Again, pre-social media, you're sitting in a coffee shop or you're at your church group or whatever, and you start, well, I'm a lawyer, and this is what I think, or worst case, when you don't really want to sit and give free legal advice, somebody says, hey, Sarah, you're a lawyer. What do you think? And you'll say, well, you're asking me something about real estate. I only do domestic relations work. I don't know nothing about real estate. And what do they say? So anyway, my question is this, and it happens all the time. I don't do probate work. Well, what do you think, though, about this? If you're answering those questions to be the nice guy, you probably are creating an attorney relationship inadvertently, because someone undoubtedly is going to rely on that advice They're loving that advice because it's free. They're asking you to affirm what they think the law should be, and you may not respond, which is what I would do. And then I kick myself later saying, you know, by not saying anything, you're affirming to them that you agree with them. And it isn't going to happen all the time. I'll tell you when it does happen is when you get involved in that area that I used to refer to as family law, and that has nothing to do with domestic relations. It means helping the neighbor, helping a friend, helping a family member. It's all in that area that I call family law that is thankless as all get out. You're giving free legal advice, and the only thing you're going to get out of it is criticism at best. Worst, if you're doing it for free or a reduced amount, you're going to get sued. So if the person has a reasonable subjective belief that they are asking you for advice, and I see it on social networking all the time, I'm a lawyer and this is what the rules are, or this is what the law is, be careful. Don't give advice. You shouldn't really give free advice anyway, right? Says Honest Abe, because it's your stock and trade. You know, with certain exceptions. If you're involved in the Nebraska self-help, you have rules that protect you. You could actually give advice at that self-help desk to help, if I read the rules correctly, to help the husband when your wife, for pay, is representing the wife. There are certain lifting of rules to allow, to encourage our less advantaged people, disadvantaged people. So you shouldn't really give advice. Be careful. I think a good way, it's not really to be paranoid, is to assume, by giving this advice, what is the worst thing that could happen? Let's assume this advice that I give, I'm wrong. What could that person do in return? It's unfortunate, I guess, to think that way, but I think it's wise to gauge your conduct knowing that it could come back to you. Keep in mind, too, I mean, there's a great article, a rabbi, I think it was in CNN, just wrote, I think I read it today or yesterday, that the whole thing, he had a bad experience when he was traveling over in Scotland and went on a bar crawl and learned a life's lesson. And he said, you know, the beauty of that was that I learned my lesson that night and nobody else really knew about it or cared. Today, that stuff will follow you for the rest of your life because there's going to be pictures, going to be recordings, etc. This one, the social networking and confidentiality, you know, I handled quite a few high-profile criminal cases, and I think it started more as therapy for me after a client I represented was executed, to just document all the things, some very interesting, some very sad, some humorous, and it was cathartic for me. But I had the idea that, you know, someday maybe I'd write a book about all these cases I was blessed to be involved in, and it would be something I could pass on to my son so he could know the deep, dark stuff behind why we had to move out of our house and all that stuff. Well, the confidentiality part of it, I realized, and it goes back, frankly, to the Lizzie Borden case where the attorneys thought it would be a good case example to provide for other lawyers, but also for investigation of a nasty homicide, that they would write a book. But there is an ethics opinion from way back when that says, no, 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 no. That confidentiality goes with the client to the grave, and even after that client's passing, thou shalt not. You cannot release this information, as interesting as you think it might be. 1.6a says you may reveal information, and you see all these examples you just look up. You can't allow a client to commit a crime. Also, you can also report something that might be confidential to try to save the client's life. They threaten suicide, and I receive calls on that all the time. To secure legal advice, when you call me and say, well, this is what the client wants to do, the client wants to lie, you can tell me that. It isn't going anywhere. And if the client says you messed up, files a complaint against you. Obviously, you're allowed to reveal the confidential information. It doesn't go anywhere because more likely than not, once I receive that confidential information about what really happened, I'm going to dismiss, and it's not going to go anywhere. And there is an interesting one there. This subsection 3 led to a very big advisory opinion, a law firm advising a lawyer in an SEC investigation was then investigated by the SEC, thinking that the firm was aiding and abetting the lawyer, committing the crime, and covering it up. May we divulge confidential information? Answer is yes. But the better objective there, the way you're better served is really seek and obtain an opinion from me, but more importantly, an opinion from a court that says, yeah, go ahead, and you can defend yourself and then comply with other law or court order. We're looking at one right now that back when I was doing criminal defense, it happened to me a few occasions. One that I can recall, a pretty big deal in federal court. The client says, this is what happened. And we go a year down the road and we're at trial. And the client says, I'm going to testify and I'm going to say it didn't happen. So, well, that wouldn't be telling the truth now, would it? I don't care. It's my case. It's my life. I'm going to get up there and I'm going to tell them whatever I damn well think I'm going to tell them. Okay. Well, I really strongly encourage you not to. I don't care. And I use the old adage, keep in mind, Mr. Defendant, I work for you. It's not the other way around. So you told me you work for me, so I'm telling you this is what I'm going to do. Ask for a recess, and the judge says, what's the deal? I need to withdraw. Why? I can't tell you. Very well. I'll allow you to withdraw. That is the easy way out, and at that time I thought the only way out. The problem with that is what? You're kicking the can down the road for him to repeat it with the next attorney and the next attorney. So now it's gotten to a point where you can strongly advise your client it's a bad idea, the jury ain't going to buy it, even if you try it, it isn't going to work, it's going to blow up in your face, you're going to be prosecuted for perjury. And on top of it, if you get up there and lie, I'm going to march into the judge and tell him that you just lied. And there'll be a mistrial, and you'll be prosecuted for perjury, and you'll get a new attorney, and you're going to go through the whole thing again. Well, there's a recent opinion out of California. I should have slid into these slides. So the court, take my example, I got to withdraw. Why? I cannot tell you without violating attorney-client confidentiality. You tell me, or I'm holding you in contempt. Well, I'm not going to tell you. You got to tell me. And if you don't tell me, I'm telling you what contempt I'm going to hold you in. And you run the risk of going to jail. And the California ethics opinion basically says you got to flip the coin of which is worse. Violating the confidentiality of your client, which runs you afoul of my office, or finding yourself behind bars because you're in contempt of a court. What you really need to seek is some sort of order that allows you to reveal that confidential information. But once you reveal it, I think the judge is going to have to recuse, there's going to be a new trial, it's just going to be a mess. Plus, undoubtedly, the prosecutor is going to find out about it, and there's no easy way out of that one. This attorney is like the one we talked about in South Carolina. He thought it was pretty cool. We have a blog about their clients and their names and stuff about them. And the lawyer says, well, wait a minute. That stuff's public knowledge anyway. Not so fast, said the Virginia bar. You need to knock off talking about your clients in a social setting more for your own personal gain at the detriment of your clients, for you dragging through the mud. The Illinois bar, again, similar assistant public defender, talked about cases, even though it was open to the public, and some of which was detrimental and indicated the lawyer may have not properly protected the client from harm by lying to the court. Advertising, the rules are the same. I mean, they're very liberal, so you should never be in a position, even in Nebraska, to get in trouble on advertising. The easy rule is if it's a current client, a former client, or a friend of a client or a friend of yours that calls and initiates, says, give me that stuff that you have on that mass tort litigation you're working on, you're fine. And we have all these opinions. I mean, we even get to the, this is the one time, it's probably the closest Dennis and I ever came to disagreeing strongly. I was going to say fight, that's giving it too much credit. We issued this opinion 1204 on, I want my client to talk about what a great attorney I am. And at first I'm like, I don't think so. Gosh, cases are so unique. What good does that do to the public to have, oh, my client thinks my client thinks I'm great because I got my client $1 million in the case. Well, what are the odds that's going to happen again? You know, and sure enough, we did all the research and the committee came out after heated debate and said, yeah, it's good. It complies with what the other states are doing. And Dennis said, that's a horrible opinion. And I've never said that about you guys. You do good work, but that's horrible. I can't believe that you came up with that conclusion. I can't believe that that's the law. I'm going to do research on my own. He called me the next week and he said, I can't believe it. I can't believe it. You're right. Majority of the states believe the testimonials are fine. Another, can you ethically advertise through Groupon advertising? Yes, that's the answer. Do I think it's bad practice to do so? Absolutely. That $500 bankruptcy, which is what this person wanted to do, you're not going to get much credit when you try to withdraw or ask the client for more money and they call and complain to me when you're out there doing that snake oil sales on Groupon. And then web-based ads are no different than any other advertising. If it's not a client, a former client, or someone saying, give me the stuff you have on that special litigation you're involved in, you must state that it's an ad. And what's the big deal? You know, people say, well, why don't you have the subliminal, this is an ad on TV or radio? Well, people know it's an ad. You know, the music's stopped. The game is not on. People know that they're listening to an ad. They can change the channel. And that letter comes, yes, they can throw it away, but most of the time the people that are asking me, what do you think about this? And I say, you got to put it's an ad. It's on that person's letterhead. The public is thinking, this might be serious stuff that's related to me. They actually are trying to help me. Well, not really. They're trying to make a buck, and they're advertising. So you need to say that. So they know that when they get it, they have the right to throw it away, just like they would if it were for you know, glass on your house or something. Not any different than witnesses or jurors. Direct contact via social networking is prohibited unless you state that it's an ad. And that's what 9-04 says. And unless you have a prior relationship, that's what 904 says. When you don't have to say it's an ad. Direct social media advertising is the same as if it were a letter or an email. You don't have to run everything by me, and frankly, if you err on the side of saying, by the way, this is an ad, you're going to be covered. And if you don't want to say that, then I'd suggest you run it by me or make a request for an advisory opinion if it's not already covered. And I flew, and we're about 10 minutes early, but do you have any questions? Anybody? They can ask. Oh, so you guys remotely didn't have any questions at all. Nobody's typing it in. Perhaps they're sleeping already. Certain things we can talk about with the ABA audit. With the opinion in Lottbaugh versus the bar, which really changed the way we do things. There have been a lot of bad experiences with attorneys feeling that they're not being included, and the change with attorney services moving out and moved over next to my office has led to confusion with the bar associations, and we're working very hard to fix those as we speak. I hope that if any of you had a bad experience last year, I think that'll be all ironed out by next year. You know, the NLAP people are still here. The client fund is still administered through the bar. And now admissions, attorney services, unauthorized practice of law is now over, moved in next door next to me over at 38th and Normal. Some of that was part of what the Bar Association audit suggested. I know the Colorado approach is basically cradle to grave. They have everything in-house with all their prosecutors. They have probation officers. They provide for probation. We do not currently. The ABA has strongly suggested that we implement some sort of probation for even first-time criminal offenses, especially if we deem that they might be in some way related to the practice of law, which I think could be construed many different ways. We presently do not. We suggest on violations like first offense DWIs that they contact NLAP, but whether they do or don't is something we do not monitor. That may be a good idea. That's something the court has asked our office to look into. Colorado does, to the extent that they issue, I think Verizon actually made a product that looks like a cell phone, but it's actually alcohol sensor, and require their people that are on first or subsequent offenses to blow into it twice a day. I don't want to get there. I mean, we do a good job, I think, both my office, but more importantly, the Nebraska lawyers of policing themselves, taking care of themselves. The business on diminished capacity is really a bigger deal, and it's heart-wrenching. Attorneys that have self-reported that they feel that they're undergoing the early stages of dementia, or the secretary that, you know, was in tears asking me what to do with someone that had become a very close friend, but she knew that he was in denial and people were covering. And in that respect, you can do it the easy way, which I encourage, which is to file for Rule 11 disability on your own and basically go to disability and active status, or you can do it the hard way, which is if the attorney doesn't respond, and I have one that isn't, that said in her own words that she could not proceed physically to practice law and represent her clients, then the hard way, I have to initiate that, and I don't want to do that. You know, before a formal charge is filed, any attorney has the right to resign, and isn't that a better way to go? Just recently, we changed our rules to provide for our disbarred attorneys that when they pass, we're no longer going to list the disbarred attorneys on the site, which was really, to me, it just seemed the right thing to do. You know, the people that, you know, the grandkids that look up and see, oh, granddad's still listed as disbarred. Well, now you can find it under the orders imposed against Nebraska lawyers, but we thought, what is the purpose we're serving? We're out there to protect the public, and what possible protection of the public are we providing by continuing to blaze out there for all to see that that attorney was disbarred? New attorneys, advice we give, if you're coming to Nebraska to get your license, or you decide you want to go home to your home state, make sure you resign. You don't let your admission or your license in Nebraska lapse, because then you're shown as suspended, and then you have to explain yourself. That makes its way to the American Bar Association database. There's no reason to do that. Just call and resign. If you're applying for admission in another state, for my colleagues in Omaha especially that want to get licensed in Iowa, if you have any doubt about whether someone filed a complaint, even if it was just ridiculous, and I opened it as a 9C, it goes on our Rolodex, your permanent record on the Rolodex, 9C against attorney X, and it shows it was dismissed, right? Well, the attorney at a very, very reputable firm was applying for admission to Iowa, and he's like, I don't know. I've been doing this for about 35, 40 years. yeah, there was that crackpot back in 1975. I'm going to put no. Well, at the same time, they're signing a waiver for the people to contact my office. And we looked and saw a 9C was opened in 1975. It was summarily dismissed. And then Iowa comes out and says, explain yourself. You said no. The officials in Lincoln are saying yes. It was just embarrassing. It didn't make any difference. He got his license, but you know, he was called to answer. And it'd be better off if you just called our office and said, hey, what do you got on me? And you might be surprised. I know I was, because I had my share of 9Cs. So, but again, like I say, if you're doing criminal defense or domestic and you don't have a 9C complaint, then you're not really trying. So don't take it so hard. It's easy for me to say, I know that. And again, I say it breaks my heart. Some people's psyche is such they get that and they go into a shell. Don't make that 9C rise to a level of a formal grievance, because ignoring the simple 9C, that all I want you to say, the dog ate it, I had a bad day, I was mad at my client, now we've made up. I just want any decent reason to dismiss. Don't ignore it, because then it gets upgraded to a grievance because you're neglectful. That's the free advice I give you. Plus, call me. Self-reporting is a good thing, as hard as it might be. Dennis, when I was contacted to represent someone for criminal conduct, this is what might happen. This is a hypothetical, Dennis. Fine. I know what you're saying. And he said, well, I'll just tell you this. It's much better if that attorney were to self-report than I read about it in the World Herald. And I took him at his word on that. And I would say that's the same way I'd treat any one of us that felt they needed to self-report on something. And I had one attorney in my office in tears because I think she thought she committed perjury because she didn't update on her MCLE site whether she was covered by liability coverage for last year. And I said, well, what did you put on this year? Well, I said that I was because I have it now, but I said I did last year and I let it lapse. I said, well, it's not the end of the world. She thought I was going to disbar her. There's no requirement to have insurance, by the way. But we just ask on the website, if you have it, put it. Of some far-fetched notion, I guess, that some smart client of ours out there is going to say, before I hire Mr. Teachman, I want to see if he has coverage. Because in the event that this goes up in a fiery mess, I want to know that I can still get him. Nobody does that. I don't think anybody in the history of the world has ever looked up to see, assuming that the lawyer that you have all the faith in was going to mess up or something was going to be terribly wrong. So just be honest on that, and do that for your change of address too, so we can track it easier. We are going to implement this database that will make it much easier to find you if we need to, unfortunately. Well, I've gone as long as I can. You guys you didn't throw anything at me, so I appreciate that. And again, I strongly encourage you to call my office if you ever need anything. I'll be glad to help. If I don't know the answer, I'll find it. Thanks.
We need to ask questions.
Sure.
What about this? I think it touches and concerns disclosing exculpatory. What about the practice in Nebraska? If you ask the preliminary hearing, you don't get the police reports.
Yeah, and I
good people give us the police reports anyway, but a lot of them don't.
I've never understood that practice. Oh, to repeat the question, someone asked about the release of reports, including exculpatory information, before a preliminary hearing. And I know the county of which he speaks, and I think the only explanation I get on that would be we don't do it because we've always done it that way. And the other counties that I've practiced in would ask me to sign a mutual and reciprocal discovery order, and I'd have my reports the very next day, well before the prelim.
No, I'm talking about if we have a preliminary hearing, you now waived or sacrificed the right to get this. So if you have a preliminary hearing, rather than you do this.
Right. Well, not ever.
No, they say ever.
Well, no. then I'm not familiar with that county because that can't be the case. I mean, that just because they want to thwart your motion to dismiss because you're going to find exculpatory evidence that they didn't produce.
No, that's just in order to avoid having to go with preliminary hearing.
Oh, well, I don't know. You know, there's certain things that I see that are routinely done that may not follow the spirit. I haven't been addressed to that specifically. I would certainly ask the county attorney to explain that conduct, but it goes hand in hand with the one that I asked. I said, if you feel that aggrieved by this process where the prosecutor says you need to plead or I'm going full bore to trial, and then knowing that she didn't have a case is dismissing routinely, you know, I have a problem with that. But it hasn't been brought to my attention other than, frankly, in a hypothetical, which is what I'm treating your question as. You know, I don't know until they respond as to why they would pursue that course of conduct or what authority they could provide me that helps them overcome Brady, you know, a constitutional violation. So those are things we're going to look into, and I'd suggest actually that you shoot me an email to that effect about that practice. At the end of July is when I sit on that panel, and the guy that's heading it up was a former U.S. attorney in Michigan who's now my contemporary for the regulatory counsel in Michigan. And he's bringing his perspective as a prosecutor, and I'm bringing mine as a defense attorney, and then we'll just run the gauntlet of what these prosecutors in other states are doing. I know Colorado takes a very aggressive approach on prosecutors behaving badly, and they go after them much more than I would say that we do here in Nebraska. I think my theory on that, on prosecutors, from a defense attorney, I never felt that aggrieved, because I think for the most part our prosecutors are just fine, outstanding people that try to do the right thing. I've always felt, in the context of being a defense attorney, that the system would fix itself. If there were an egregious violation on discovery, for example, there's going to be a new trial. There may be sanctions imposed, etc. Probably as much or more than my office would do, unless there's criminal conduct or something like that of you know, tampering with witnesses or things like that, which we do take seriously, and I've actually investigated even since September. So shoot that to me, though, and I'll raise that as one of the issues that we have here in Nebraska when I go out for that conference. Any other questions? All right, I'll let everybody get back to work. Thanks for coming.